All right, record should reflect that a bench conference in this case, the probable cause conference in this case will be adjourned to June 17th, 2025. 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case of the People versus Carlos Payne.
As on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergil Smith, and on behalf of Carlos Payne, who appears via Zoom. Mr. Payne, please state your name.
Carlos Payne.
You got him. Okay.
Your Honor, we are asking to set a preliminary exam in these cases, and I would ask to address his bond conditions.
All right, so discovery is complete in both matters?
To the best of my knowledge, it is, Your Honor.
All right. People in these cases have their witnesses available the third. Okay, in these matters, preliminary examination will be set June 3rd, 2025, 9 a.m. before Judge Perry. As to bond.
Your Honor, we are asking the court to consider allowing him to remove his GPS tether, of course, keeping the no contact and no go-to orders in place. He's been on the tether a few weeks now with no violations. He lives in a separate city from the complaining witness, with him living in Detroit and her living in Ypsilanti. He does work full-time. He shares a child with the complaining witness, but I spoke with him about how he can meet with her or meet with a third party to exchange the child if necessary. For financial and just general comfort reasons, he's asking to have the GPS tether removed, as well as he's got a physical job. It does get in the way. Again, full-time, working, no violations. We ask you to consider removing his tether.
Is there any response from the people?
Your Honor, we would object to removal of the tether given the facts of these cases. They're very serious. One of the cases in GBH in which he was dropping off belongings for their child. After dropping off these belongings, he came at the victim, got in her face, they went upstairs. He was stating he was going to kill her and her mom and then punched her in the head. He then got behind her, was strangling her from behind with a headlock and slammed her to the ground. And then in the other case, he threatens her with a knife and a gun, saying that he would shoot her through the door. So I have great concerns for her safety and would ask the tether remain here.
Your Honor, he of course denies the allegations, but further, he has shown that he can comply with bond conditions so far, fully compliant. I don't believe that that would change simply due to the tether removal. He understands the risk of being brought back into custody if he were to violate.
Motion for bond reduction or bond modification is denied. GPS tether will continue in place, and certainly feel free after the exam to bring that up for Judge Perry. I'm going to deny it at this time. All right, thank you. Court calls the case People versus Taiwan felon.
Representatives from people.
On behalf of Mr. Taiwan Phelan.
Phelan. State your name.
I just realized.
Taiwan Phelan.
Phelan. Correct. I remember from the last time.
Oh, I already have one. Sorry about that. I'm not doing well today. Your Honor, we were going to be requesting an adjournment to continue plea negotiations with the prosecution. I can't believe I forgot the green sheet, but
I don't know. You said you had one and then you didn't have one.
There you go.
What I'm talking about. I just.
Here's a key legal nugget. PR means personal recognizance. Basically, the judge is trusting the defendant to return without posting money. High stakes on honor alone. Would you trust them?
Cards conference will be adjourned June 5th, 2025, 9 a.m. or as your invite indicates, bond will continue. Thank you. Court calls case People versus Austin Lee Ray.
Good afternoon, Your Honor. Chief Assistant Prosecutor Victoria Burt here is appearing on behalf of the people. Hannah Mackey on behalf of Mr. Ray. Your Honor, we've been trying to get a hold of Mr. Ray. We have not been successful. I've reached out to his CMH worker who has also been trying to reach out to him. So we respectfully request an adjournment to see if we can find him.
He also has a violation, community corrections violation report.
He does. He has failed to report to community corrections. I think the problem is, Judge, just no one has heard from him or seen him, and he's done nothing to report to.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Joanna Reed.
Assistant Public Defender Jay Bellinger on behalf of Ms. Reed, who approaches, Your Honor.
Your name, please?
Johanna Reed.
And you're requesting forensic referrals.
We are, Your Honor. I have submitted that to the court for its signature, and I would also ask to address a condition of her bond when appropriate.
Forensic evaluations are ordered. I'll set a competency hearing for 90.
August 14th.
August 14th, 2025. 9 a.m.
Thank you, Your Honor.
Esteban.
Esteban, Your Honor, my client is requesting that she not have to drug test anymore. I know that that is generally a basic condition of bond. However, the allegations in this incident don't prescribe to the fact that she was using, there's no allegation that she was using drugs or alcohol. This is a case, Your Honor, that I have submitted for competency, certainly. But with regard to the drug testing itself, my client simply can't afford to do it. She does not want to get a bond violation for her inability to afford it. So we would ask that the drug testing cease at this time.
Response.
Your Honor, the people actually don't have an objection. I don't have any information to indicate that Ms. Reed has ever had a substance abuse problem. She was recently petitioned a month or two ago and is currently undergoing by court order. And so, Your Honor, at this time, I don't see that.
I'm trying to see what was the original. You say she's drug testing off of this case?
That is my understanding, Your Honor, based on my
Does
conversation.
she have any other matters pending? No?
Not because people know, Your Honor.
Being asked for the drug test right now,
Every week.
every week.
Ma'am, do you have any other cases pending?
I think so.
Your Honor, she advises she's being asked to drug test once a week on this case.
Your Honor, I'm wrong. She does have another case. She does have another case.
Oh, not one. Oh, okay.
OWI out of 15th?
I
I
apologize.
don't have a drug testing order.
Your Honor, I apologize. That was something that I wasn't.
Hey, no, I'm used to you wasting my time. So I can't.
Understood, Your Honor.
No, I got you. So August 14, 2025, 9 a.m. Bond will continue. All right, thank you.
He can't do anything about the testimony. I have to ask the 15th district court parties to do that.
Nothing. Court calls the case People versus Deborah Spears.
Hannah Mackey.
If you were to be different people.
Hannah Mackey on behalf of Ms. Spears, who is on Zoom, I believe.
Ms. Spears? You try.
I am.
Drama meets reality, a chipped tooth being argued alongside competency and public safety. It's moments like this that remind us how deeply human and messy these court proceedings really are.
Good morning. Can you hear me?
There she is.
I'm sorry. I'm not sure what's going on with the Zoom.
Oh, okay. Ma'am, how do I spell your last name?
Spears.
Okay, we'll need to amend the complaint. The spelling of her name, I think off of the complaint is Eers.
Yeah,
Just
it
double
is.
check. Yeah, I think. Well, actually, there's an AKA that covers it. That's why. It's EERS, and then there's an AKA also known as with the last name spelled EARS. So I think we're good. All right. In this case, I have before me a plea form that indicates the defendant is going to be pleading guilty by to the offense of embezzlement by an agent or trustee, 200 to 1,000. The 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There's further an indication that the defendant must pay $1,170 restitution in full to Speedway to comply with all other conditions of probation of the court sentence to receive the dismissal of count 2 via prosecutor's deferred. Okay, that's a lot, but okay.
That's the correct statement, Your Honor.
So I guess I'm trying to figure out what's going to happen if.
Yes, Your Honor, I can clarify. There was previously discussion of a resolution in this case with prepayment of restitution. When this was pending back in 2023, Ms. Spears had not been able to make those payments at the time, and then she was out for a while on the bench warrant. So we decided to resolve it in a way that will have her commit to paying that amount rather than a prepayment, so that we don't end up in the same sort of cycle. I did also add a prosecutor's deferred to that offer as well. So when she does repay that amount, whatever the sentence may be in the other court, if she complies with that, she can get a dismissal of
That's your right.
That is correct, Your Honor.
Ms. Spears, can you please
Yes.
raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, please.
Deborah Spears.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine can be increased if 3 times the value of the property, which is the subject matter of the theft or embezzlement. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Now, taking all of that in consideration, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I did. Well, I gave permission because I'm not in Michigan, so I gave permission to Miss Apple to sign it on behalf of me.
All right. And they went through that with you, correct?
Yes.
All right. And they explained to you your trial rights, which are contained under paragraph 5.
Yes.
And you understand that you are waiving those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes,
of your own free will
yes,
and because you believe that you're guilty of this offense?
yes,
January 4th, 2019, at the location of 2020 West Stadium Boulevard in the city of Ann Arbor, Washtenaw County, state of Michigan, were you an employee of Speedway Speedway gas station?
yes. Mm-hmm.
And what did you do that makes you think that you're guilty of this offense?
I took money from Speedway without their permission.
All right. And the amount of and you came into possession of that money by virtue of the fact that by virtue of the fact that you were employed there, correct?
Yes,
All right. And you didn't have anybody's permission to take that money, did you?
no,
And this money, you converted this money to your own use,
yes.
meaning you spent the money.
I did.
All right. And the amount was in excess of $200, correct?
Yes, I honestly, I only know the exact amount, because you guys tell me, but yes, I believe it was more than 200.
All right. You're not disputing that you took more than $200.
No, no.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People satisfied.
You have your honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
June 17th at 9 a.m. with Judge Valvo.
June 17, 2025, 9 a.m. before Judge Valvo.
Okay.
Bond will continue.
Thank you, your honor.
Thank you.
Ms. Spears, I'll be in touch, okay?
Okay, thank you. Have a
Any other messages? You know what?
great day.
All right. Thank you, Ms. Spears. I don't know.
Thank you.
Why
I'm
make
sorry
you-
the Wi-Fi cut out, but thank you.
You're welcome.
Lock this date in, Sentencing Day. This is where all the legal back and forth finally lands. Think of it like the season finale of a long, tense drama.
Court calls the case People versus Carl Tenzin. I don't know why Mackie has a cell phone.
Here to make that for the people.
Talk to
Anna Mackey, on behalf of Mr. Tesson, who is approaching. Please state your name for the record.
Tenzin. Thank you.
Your honor, I believe we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available on the 3rd. Preliminary examination in person, June 3rd, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Thank you, your honor.
Thank you. Court calls case of the People versus Matthew Vermillion. Vermillion?
As on behalf of
Assistant Public Defender Chelsea Vergils with him on behalf of Matthew Vermeulen. Please state your name for the record.
Matthew Vermillion. All right, you're requesting an adjournment.
Yes, there's some discovery yet to be received in this case, and I would ask to address a condition.
in your estimate discovery, you did request it yesterday, so it should.
Got it. Should be here soon. Okay. Probable cause conference will be adjourned June 5th, 2025, 9 a.m. Yes, Esteban.
Your Honor, we are asking to have the no contact order lifted. My client has been staying with his mother in Chelsea. He plans to continue doing so. We're not asking to have the no go-to order lifted. I think the concern in this case is that my client's family typically runs a business that the complaining witness may be involved in, and that business needs my client's help to continue running. That business is not anywhere near the complaining witness's home, from what I understand. He understands what consensual contact means and is committed to continue following his bond conditions. He hasn't been on bond long, but in the time he has been, there have not been any violations. I believe the complaining witness may be here to address the court today.
She is present today to address the court.
All right. Step back. Where is she? Ma'am, come on now. Hello.
Hi. So I own a business with Matthew's sister. And
Hold on, hold on. Hold on.
Oh,
I know
sorry.
you were ready to start. You got to that line and just took off.
Sorry,
I need you to state your name.
Amy Phillips.
All right, now go ahead.
I own a business with Matthew's sister, and he's played a vital role in the business for the last 2 years. We're about to get into a really busy season. It's a canoe and kayak rental business. So I would like to ask to remove the no contact order so I can efficiently run our business.
All right. Okay. All right. And you think that he will cooperate with a no non-consensual contact?
I do.
All right. Thank you, ma'am.
Thank you.
Any objection from the people?
This time I would object. This case was just arraigned on 5/13, and I have serious concerns with this case. It involves him going to Miss Phillips' house in the middle of the night to take her phone to go through it. She wakes up, calls 911. He comes back to the house, walks in, is screaming at her. She had her foot in a doorway. He slams the door on her foot 5 times. And then she went to call 911 again. He saw her on the phone, chased her to the back of the house and tackled her while she was on the phone 911, ripping it from her, the phone from her hands and throwing it at a wall, breaking it. I just have concerns given the facts of this case. And from that, she had a contusion on her thigh, bleeding on her foot, and on the back of her foot a cut. So I just have concerns given the facts of this case and how recently this happened for any contact at this point, and would be objecting.
Anything else, Mr.
I would just say that my client and I feel strongly that he is able to comply with court orders and that there wouldn't be any further criminal activity from my client, and that the bond conditions with the no contact order lifted are sufficient to protect the complaining witness, who can revoke consent for that contact at any time.
I will grant the request. I will delete the no contact provision, having heard from the alleged victim in the case. I'll delete the no contact and add no non-consensual contact. So young man, you understand what that means, that if she doesn't want you in her presence, you must immediately leave.
Yes, Your Honor.
And that,
Yes, sir.
all right. With that added condition, bond will continue, or that adjustment.
Thank you, Your Honor.
Thank you.
Court date's on.
Court calls the case People versus Aaron Washington.
Thank you, Richard McGiffey for the people. First Assistant Public Defender Clint Anderson with on behalf of Mr. Washington, who's here.
What? Where is he? Where'd she just ran out? Pass it. Yeah. Court calls the case People versus Cynthia Weber. I pass it. I'm done. I'm done. I'm so done with you. I'm done. I'm done. Cynthia Weber. I called the next case. Cynthia Weber, come on up. Don't pay attention to these people.
It's
Your name?
Cynthia Weber.
Okay. That's yours too?
You want my name?
Is that yours? Is that yours too? I was hoping to call one that wasn't yours.
May I approach?
Oh, wow. Really?
No, not really. I just. I figured since you didn't want to see me, I was going to see me up close.
Yes, you can go ahead and put your.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Weber. Your Honor, Ms. Weber is in treatment. We're trying to get some treatment information and allow her an opportunity to complete. She's set to complete on June 10th, and we'll be
Okay.
going to residential after that. So
Got
if we can have the next available date.
After the
that.
10th, you want.
After the 12th, because
Af-
she's gonna go to transitional, get set up, and then get the information on
Then
that.
she'll have, okay.
Mhm.
So I will adjourn this to, it's actually a Tuesday, the 17th,
Okay, June 17th.
June 17th. That's at 9 a.m., 2025.
Okay, and I put my email there, but I think they already have it. Somebody sent me something.
Bond will continue.
Thank you, Your Honor.
Thank
You're
you.
all set.
No, not doing it.
Can we please?
No. No, I'm not gonna punish you.
Washington is,
What?
but Mr. Washington is here, though. He was just right outside the door. He didn't even go far.
I know, we all heard you screaming at me.
Oh. The shade of it all. What is happening right now?
No, she has been throwing shade at everybody in your office all day.
All day.
Well, all what she did to Miss Mackey,
I'm so glad you noticed.
that hurt my feelings. Court recalls the case, People versus Aaron Washington.
First Assistant Public Defender Kalita Anderson with it on behalf of Mr. Washington, who's approaching.
Good afternoon, Aaron Washington. Sorry for the discrepancies.
No, you know what? You were fine. It was your attorney that was having an issue. I mean, you were just sitting out there peacefully in the hallway, and then she came out screaming at you, didn't she?
Yeah, I was.
I know. I know. It scared me too.
I disturbed his peace, Judge. I'm so sorry.
My heart dropped.
And why do I have two green forms?
Okay, so what happened?
Able to scream at me as well. Demanded that we adjourn.
Oh.
I've never spent a day in my life. No, my circumstances changed for why I was adjourning, and that's why I gave you another phone.
Okay. So I don't know which one was the later one, but do you want 3 weeks?
Sure.
Is that what you were looking for? Or?
Do you need 3 weeks?
Good.
Oh, she does not. Next available, I'll be ready.
Mr. Washington.
You know what, Judge? I should have given you a pink sheet to go with that green sheet, and then you could have kept them both in the. Just saying.
And you know, because of my sister, I'd have to throw it out and tell you to get me a red one.
I don't want anything red.
Stop. Seriously. I can really sit down.
Right. We should change the colors of these mic lights.
That what?
That's okay. Your courtroom's beautiful, Judge. But you do have a green light here.
Poor Mr. Washington may have to find a new attorney.
Don't leave.
The
me,
one
Mr.
standing
Washington.
next to him may be locked up in a minute.
Oh, okay. We're good.
That's okay. You can go to visitation and see her.
Keep me in good favor.
Mr. Washington's like, let me out.
Please.
Right?
I almost had a heart attack in the hall.
I know, but that is not my fault.
I thought she said bench warrant or something. I'm like,
That's
what?
right. And I had no intention of that.
Thank you. Thank you.
Right.
June 5th,
I would never say bench warrant. That's
June 5th, 2025, 9 a.m. Mr. Washington's bond will continue. Thank you, sir.
Thank you.
Did you and Bishop making a comment?
No, not yet.
Oh, Mr. Yeah. Court recalls case, People versus Alante Lindsay.
Assistant Public Defender Chelsea Vergils with and on behalf of Alante Lindsay. Mr. Lindsay, please state your name.
Alante Lindsay.
Thank you. Have I been able to stop anybody all day? Come on. Come on, but Mr. Lindsay wasn't here. Did she yell at you? No. All right.